Please note that this is part one of a two-part slide set on the background and purpose of equal employment opportunity law. Equal employment opportunity law is deeply embedded in American history and culture. In fact, it is so deeply embedded that its content and ethical logic cannot be understood unless we take some time to understand the historical debates and compromises that led to the form as we presently see it. In the U.S., the Constitution is held in the highest regard. In fact, there are many who revere the Constitution as a special kind of secular sacred text. Those who study constitutional law know it to be a profoundly enlightened document, crafted with the noblest goals, but shaded by the flaws of the society that gave rise to it. By far, the most difficult and flawed part of the Constitution was the problem of slavery. Slavery existed before the Constitution was ratified in 1787, and it remained legal until after ratification of the 13th Amendment after the Civil War. The subsequent 14th Amendment broadened the definition of citizens to include African Americans, guaranteeing basic legal rights such as due process and equal protection under the law. You might want to check out the recent 2012 movie Lincoln to gain some insight into the constitutional struggle over civil rights. The movie showcases passage of the 13th Amendment abolishing slavery in the United States. As you will notice from this slide, once the constitutional barrier had been cleared, over the ensuing decades, there have been a number of statutes, executive orders, and judicial decisions that have defined civil rights in a manner well beyond the narrow question of slavery. The path toward greater civil rights has not been easy. To understand contemporary civil rights issues, it's useful to consider the following factors. In the post-Civil War, a number of southern states instituted what came to be known as Jim Crow laws. The Jim Crow laws were state and local laws enacted between 1876 and 1965. They mandated de jure racial segregation in all public facilities in states of the former Confederacy. During this period, the national judicial system endorsed the principle of separate but equal, helping to firmly entrench a culture of inequality. The arrival of World War II, or more specifically, the end of World War II, had significant ramifications for race relations in the United States. By 1942, there were 200,000 African Americans serving in the armed forces. During the war, the Roosevelt administration tried to pass a bill that would make it easier for soldiers stationed away from home to vote in national elections. Southerners, fearing the loss of white supremacy, defeated that effort. Senator James Eastland of Mississippi explained that the reason for objecting to the law was that those boys are fighting to maintain white supremacy. Black soldiers, returning from the European and Pacific theaters, came home to find themselves living in a society at variance with the ideals they fought for. Young, trained, and confident, they became civic leaders and joined others committed to ending racial injustice. Brown versus Board of Education, decided in 1954, was a watershed moment. Not only did it redefine the balance of power between state and federal governments, it opened the floodgates of social activism. Shortly thereafter, Congress took up debate of the Civil Rights Act of 1957. It was during this debate that ardent segregationist Senator Strom Thurmond of South Carolina sustained the longest one-person filibuster in the history of the Senate in an effort to defeat the bill. His one-man filibuster lasted 24 hours and 18 minutes. Thurman served in the U.S. Senate until his death in 2003. 6 months after his death, it was revealed that at age 22, he had fathered a mixed-race daughter, Essie Mae Washington Williams, with his family's maid, Carrie Butler, then a 15-year-old black girl. Thurman never publicly acknowledged his daughter, Essie Mae. When President Johnson assumed office following the assassination of John Kennedy, one of his primary agendas was to move forward on the question of civil rights. The 1964 Civil Rights Act was distinguished by previous efforts by the inclusion of Section 7. Earlier civil rights legislation had focused on securing voting rights and related rights of political citizenship. Title VII was something new. Title VII was different in two major respects. First, it embraced the argument that political equality alone would be insufficient. Political equality without equal employment opportunity was now recognized to be a hollow victory. Second, in order to secure economic equality, employers would need to become agents of social change. The law, in effect, mandated that employers proactively divorce their organizations from the embedded prejudice of racism. Title VII created the idea of protected groups, and it explicitly mandated action by employers. This represented a major shift in thinking about racism and the social responsibility of business. Two decades following Brown versus Board of Education were tumultuous. U.S. Senator Harry F. Byrd of Virginia, with the support of Senator Thurman, assumed leadership of what soon became known as a strategy of massive resistance. Throughout the South, new laws were written and policies adopted to prevent public school desegregation and challenge the authority of the federal government at every step. These efforts failed over time, but the racism that fueled massive resistance was slower to dissipate. Over time, it became clear that there were two kinds of racism: disparate treatment, which is clear, intentional, in-your-face discrimination, and adverse impact. Adverse impact, also known as disparate impact, is a kind of discrimination that is more subtle. It is the kind of discrimination that can be woven into the fabric of society. At one point in my career, I lived in Marietta, Georgia, about 2 miles away from the home of Lester Maddox. Lester Maddox, featured in this picture, owned a restaurant in Atlanta, Georgia. He was an ardent segregationist and argued that the government had no right to tell him who to serve in his restaurant. In this picture, Maddox and his son, Lester Jr., are driving away a protester from his restaurant, the Pickrick. Lester Jr. is carrying a pickaxe handle, Lester Sr. a pistol. In 1965, he closed the restaurant rather than comply with the public accommodation section of the Civil Rights Act of 1964. The axe handle became known as the Pickrick drumstick. Replicas were sold to diners as souvenirs. Lester Maddox was the first person convicted for civil contempt for refusing to serve Negroes under provisions of the 1964 Civil Rights Act. He turned his resistance into political advantage and served as governor of Georgia from 1967 to 1971. The actions of Lester Maddox provide a good example of disparate treatment as a form of discrimination. There was no doubt that Mr. Maddox used race as a reason for his intentional discrimination. Adverse impact is more subtle. Only recently, for example, has the U.S. military dropped its blanket policy of preventing women soldiers from assignments in major job categories. Why have they been denied access to these jobs? Because it was assumed that female soldiers, by virtue of their being female, were unqualified to perform the required duties. The source for understanding the controversies surrounding adverse impact can be found in the language of the Civil Rights Act. Section 703 not only defines the major protected groups, namely race, color, religion, sex, and national origin, it also places great emphasis on the importance of individual qualifications. In the two paragraphs on this slide, the term individual appears no less than 5 times. Why? It was because Congress wanted to make it very clear that equal employment opportunity was an individual right, and that access to employment opportunities depended upon individual abilities, not group membership. The most influential judicial decision on the question of adverse impact was Griggs versus Duke Power in 1971. After 1964, it didn't take long for people to begin to recognize the degree to which racism had been woven into the fabric of society, especially into the fabric of the employment relationship. In Griggs, a group of 13 African American employees who worked for the Duke Power Company at its Dan River Station in Draper, North Carolina, sued in an effort to secure access to promotions. Duke Power had a long history of segregating employees by race. At the steam station, the best jobs were reserved for whites. African Americans were relegated to the labor department, where the highest paid worker earned less than the lowest paid employee in any of the other 4 departments where only whites worked. Shortly after Congress passed Title VII of the Civil Rights Act, Duke Power stopped expressly restricting African Americans to the labor department. It announced new standards for hiring, promotion, and transfers. Under the new rules, in order to work in positions outside of the labor department, Duke Power now required a high school diploma or scores on standardized IQ test equal to those of the average high school graduate. These new requirements were not an improvement. However, in terms of raising the quality of workers or preventing race discrimination. The record shows that these rules effectively perpetuated the discriminatory policies that Duke Power had utilized prior to the enactment of Title VII. In its unanimous decision, the Supreme Court struck down Duke Power rules because the company never established that the test successfully measured ability to do the jobs in question. Indeed, the white employees, not having taken the test, hired before the requirements were imposed, performed entirely satisfactorily. In this decision, the court ruled that employers could indeed use professional testing for employee selection, but those tests must have been validated in a manner to clearly demonstrate their job relatedness. This is an important concept, job relatedness. In other words, tests that could predict future job performance were legal. Tests that had no relationship to job performance but only served to perpetuate past prejudice would not be allowed. The adverse impact standard has always been controversial. By the mid-1980s, the political climate in the U.S. moved in the direction of those who had doubts about how Section 7 of the Civil Rights Act was developing. Most skeptical were conservative appointees appointed to federal judgeships by President Reagan. A number of courts were invalidating what many considered to be settled matters. The apex of this trend appeared in the Ward's Cove decision of 1989. In response, Congress joined with a broad coalition of business and civil rights leaders to pass the Civil Rights Act of 1991. This might be thought of as the EEO Restoration Act. The Civil Rights Act of 1991 did not break new ground. What it did was to reassert as legitimate interpretations of the law that it had emerged over the previous 2 decades. That said, it did make some changes. Most notably, it made it easier for employees to sue, it capped potential employer liability at $300,000, and it increased the opportunities for class action damages. Given that there are 2 primary forms of discrimination, there are 2 different paths for the plaintiff to demonstrate that discrimination has occurred. Because disparate treatment is overt, plaintiffs charging disparate treatment bear the burden of providing evidence of that treatment. It might consist of a written document or public statement. For example, the use of derogatory terms in a statement to workers or the public would become evidence in a case of disparate treatment. Adverse treatment, or adverse impact, is more difficult. In these situations, the plaintiff bears the responsibility of demonstrating that subtle discrimination is occurring. Recall the Griggs versus Duke Power case. The selection rules implemented by Duke Power superficially looked non-discriminatory, but in reality, they served to perpetuate discriminatory practices from the past. To address this dilemma, the EEOC uses 2 important standards. The first of these is the idea of the prima facie case. Prima facie means on its face. In practice, it means that the plaintiff bears the responsibility of demonstrating to a reasonable person that discriminatory practices are operating. In the Griggs case, the plaintiffs established a prima facie case in part by showing the disproportionate failure rate of black applicants over a comparable sample of white applicants. The second standard of importance is the burden of proof rule. The burden of proof rule states that once the plaintiff has met the threshold of establishing a prima facie case of discrimination, the burden of proof shifts to the defendant employer. In the Griggs versus Duke Power case, after a prima facie case had been demonstrated, the burden shifted to Duke Power to demonstrate that its selection tests were not discriminatory. This means the means by which they would be demonstrated as non-discriminatory was by providing evidence that they were reliable and valid predictors of future job performance. This ends part 1 of our discussion on the background and purpose of equal employment opportunity law. In part 2, we will explore in greater detail the process of building a prima facie case for adverse impact, and then showcase the extension of protected group status to the disabled and older workers.